My dear Professor Thomas Hoeren is one of the legal advisors of the European Commission at the Legal Advisor Board on Information Technology. He's also a board member of the Research Center for Information Law of the University of St. Gallen, Switzerland. Since June 2000, he has been working as a domain name panelist for WIPO. In 2005, he became a member of Expert Committee for Copyright and Publishing Law at the German Union for Intellectual Property Protection. From 2012 to 2014, he was a dean of the Faculty of Law at the University of Münster. Since 1997, Professor Hoeren is based at the Institute of Information, Telecommunications and Media Law at Westphalian University in Münster, Germany. He has been a Superior Court judge, and over the last 20 years, he has been involved in research on intellectual property law and computer law. Since 1997, he is director of the Institute for Information, Telecommunications and Media Law, ITM, and as he told several times, he's not a fan of the traditional view of IP law. He created the Institute for Information Society, where intellectual property is only a part of it. He is also a great and very committed and recognized photographer. And he has a lot of great things in ITM, and he's a very big guy that helped us to do a good research at Münster University. So I thank you very much, Professor Hoeren. And now I introduce Professor Ramon Alberto dos Santos, and he will speak about the use of data by artificial intelligence applications. PhD in law from University of São Paulo, Bachelor of Law from the State University of Maringá. He was a researcher at Innovation Teaching and Research Group and at the Teaching Methodology Center at the São Paulo Law School of the Getúlio Vargas Foundation. He is currently Associate General Counsel in the area of privacy and personal data protection at Meta for Latin America and Canada. And now I will introduce you, our third speaker, Professor Dr. Denton Zanetti, Open Data in Brazil, an overview on regulatory tendencies. Professor Denton Zanetti is lawyer and professor, master and PhD student in law from the Pontifical Catholic University of Paraná, coordinator of the postgraduate course in digital law at PUC-PR. So we are very happy and grateful to have you here with us, anxious to hear from you. And now I can call Professor Thomas first to talk. Please, Professor Thomas, you can start.
Yeah, thank you very much, Angela. I really appreciate this very honorable invitation and the nice introduction. I'm totally attracted to the data law, especially in the EU. I didn't expect to have such a high regulation of the data law happening in Europe when I started as an information law professor. The total mentality in Europe has changed due to the fact that they have made so many regulations that even the clever guys cannot understand who is doing what in this moment. Oh, my slides are missing. Oh, it's okay. Therefore, I have been asked in the next slide to tell you more about the EU data law. That is a very specific part of a bigger general data strategy. And I'm fascinated because I thought 1 year ago when I was here, they will never manage to have that Data Act, but they managed to have it finished. So there's a great chance on the 3rd of July, Parliament and Council and Commission agreed on a so-called trilogue text, which I have distributed to Angela So if you are interested to get a 140 pages text where you can see what is happening, but I am more fascinated now to tell you more about the aspect of this new law relating to data property. So, and to start the story, next slide. I'm a fan of Volkswagen. This is a great car. They are produced 150 kilometers from here. You see a lot of cars from Volkswagen, and they're producing high ranges of every variation of electronic cars and digital cars and so whatsoever. But yes, when you buy a Volkswagen, next slide, you see they have a whole range of computers integrated. This is a model which I don't want to explain. It shows you the batteries in a Volkswagen, which are connected to a lot of computers and boxes and tools and microcontrollers and loggers. So if you buy a Volkswagen, you buy at least 30 computers, which can easily show next slide. You see some of the computers integrated in a Volkswagen. So more than 30 computers, they are collecting on a certain state of using a Volkswagen, they are collecting more than 50 million data which are produced by the car. Next slide, you see this slide and slides. And you can see they are all checked and controlled. The Volkswagen is proud to be the owner of this data, and they're using it for whatever purpose. They're checking speed, they're checking altitude, distance, and so on. The problem is, however, who is the owner of this data? Can Volkswagen say, we are the right holders of the data? Next slide. Because in the next slide, you see the problem is with data, that data are not very normal objects of regulation. So, for instance, they are non-rival. So it can be used by several people at the same time. It's totally an anomaly for lawyers to have a good which belongs to everybody. So that's a dream of Angela and myself. Information cannot be earned by a single person. So they are overall and can be used by several people at the same time. They are not exclusive. They are unlimited by nature. So they are not related to a person. The dream of Angela and mine, they have a common heritage in information. And they cannot be used by a single person, but they are used by everybody. That's what I've written with a guy, a strange guy, a close friend of mine, Mr. Pinelli, in a long article. Mr. Pinelli is the head of Volkswagen legal department, and I've discussed it with him for several years, and then we have written a long article about it. The question, next slide, for us is the question, who owns the data? So, for instance, can the data be a subjected, governed by the data protection law? I'm happy to say that Brazil has a wonderful data protection law, very fascinating to read it. But the problem is with this data from Volkswagen, these data are not cannot be governed by data protection, because data protection is not a tool for building up property rights. Data protection is a tool for protecting people against misuse of data. So they don't give exclusive rights in data. Second problem, what is a personal data? What does it mean to be personal as such? And you can imagine, in a Volkswagen, we have certain data, which are of course part of data protection. If you can trace a natural person behind the data, but take, for instance, the simple data of speed, oil, electricity in a car that is not related to a natural person is not a subject of data protection law. And last problem, we have apparently an area outside of data protection, that means data law, which is not governed by data protection law. Therefore, all the structures of data protection law cannot be used in that area. Next slide. Yeah, this is a quite easy question. Perhaps we can have property in data, because we have, in Europe at least, a database law. We have a separate protection in copyright law for databases. But again, the database protection, as shown by the Federal Supreme Court in Germany, is a protection tool for the way data are structured. So only the structure of data is protected, not the simple raw data. That is a big major problem. Therefore, we cannot apply all the structures of database rights. Next slide, please. In the next slide, you see the problem. Even the normal traditional civil lawyer doesn't know how to cope with this data, because data cannot be regarded as goods under traditional copyright law, civil law, because goods mean corporal objects, and data are not corporal. They are not rival goods, so they don't fit with property law. We had a vision in the criminal law that we have a regulation in criminal law 33A, which says it's not allowed to change foreign data and the data of a third person. So you should know what does it mean, a data of a third person, and what is meant with own data in criminal law. But if you ask a civil lawyer, can you learn from criminal law, he would totally say no. German civil lawyers never learn anything from criminal lawyers. So the criminal lawyers in Germany have a kind of concept, which explain data, for distinguishing own data and the data of a third person. I have written several articles on it, and I have the feeling that it's possible to take law of possession, because the law of possession can give you a chance to build up a legal regime for the protection of the data. But nobody believed in my theory. So I've written another article. Perhaps it's a protection of secrecy law, which can be used. Next slide. Well, I can show you the answer of German courts. The Federal Court of Appeal of Brandenburg said, we don't believe in the theory of law of possession regarding goods, and therefore they even cited me and said, see, Hoeren and Michel, they have written totally rubbish articles on law of possession applied to data. Very, very sad story. Next slide. Next slide. Therefore, I was very fascinated to see what is happening in Europe. Europe invented a new data strategy. They said data are very valuable. We can use the data and we should build up data as a new economic factor. Next slide. They made various regulations, for instance, proposal for data governance, very important, a Data Governance Act, which tries to promote the idea of free exchange of data. So we made the Data Act, which I'm now talking about. We invented the Digital Marketing Act to find a tool for protecting European business against the power of Google and Apple. And next slide. In the next slides, you will see that is not all to have the Data Act and Data Market Act. They have made Data Protection Act. They have made regulation, next slide, on Digital Services Act. Even the EU Chip Act has been made for establishing a big semiconductor industry. So what I can recommend, 2 slides more. Next slide, yeah, is of course I want to promote. I have made a book, very nice book, not on the far. I've recommended a very new book, which I published again with a guy called Pinelli, the head of Volkswagen Legal Services, on the new acts from Europe. So it's a very cheap book. If you want, you get a free copy from, send me an email, I will send it to you. Next slide, I will show you the special importance of the Digital Act. There you see, on the 14th of July this year, they have made an agreement for a new Data Act, Lei de Datos. That's brand new. And the fundamental, next slide. Next slide shows you one nice feature. Take my Volkswagen, which I use as a symbol starting this lecture. The vision of the Commission is Volkswagen is storing millions of data in a car. And the person who is driving a car, the data user, should have a right to use that data. That's important. So Volkswagen has to give away a license for the user that he might get all this data. That's the vision behind this. Next slide. That means they have to make a regulation for rights of the data user versus the data owner. And they had to define what is a data owner. And I was totally enthusiastic that the Commission said data owner is the person who is possessing data. So my idea of the law of possession, which needs to be applied, even the vision of criminal lawyers had the same vision. The person who is storing data are data owners. The Commission said in the preamble, we don't want to invent a new ownership concept, but as a matter of fact, they are doing it. They are attributing rights to Volkswagen and said, you are the owner. Then we have a data user, and next slide, which shows you the problem. So the Commission said the use of non-personal data resulting from the use of the product, for instance, driving a Volkswagen, is prohibited even for Volkswagen unless there is a corresponding contractual agreement with the user. So Volkswagen has to give the data via a data license to the user. Very important. That means Volkswagen is now in a chaotic situation. They don't know how to cope with that. They have to write thousands, millions of data licenses with each user of a car. So that is the problem of Volkswagen. But next slide shows that Volkswagen has another problem then. What is happening with secrecy law? So for instance, if the data user, the simple Volkswagen driver, has all this data, why should he, what does he make with this data? So you have a huge file in your private home with all this data. Of course, that can be made, can be used for money. So big companies can ask, can't you give us all the data so that we can use this data? Take, for instance, an independent repair service of a Volkswagen. They can ask the users to hand the data and then to use the data for independent repair Volkswagen. Can Volkswagen say, this is a secret, that these data belong to us because there's secrecy law? No, the Commission said, no. Of course, you have to take care for secrets, but secrets are not an excuse for not giving away the data. That's a very big danger, and the Council and the Parliament said that's dangerous. We should help Volkswagen to get their secrecies protected. Another problem, next slide, and this problem can absolutely not be solved. In the Article 1, the Act simply said we don't want to contradict to any regulation in the General Data Protection Directive. So the General Data Protection Regulation is superior, is more important than the Data Act. So next slide, I can show you the effect. So if Volkswagen is giving data away without taking care for data protection, they get punished under the GDPR. So, but if they don't give the data away, so they might get punished under the Data Act. So there's a clear contradiction of two huge regulations which contradict to each other. So you will see wonderful things. That means we have a lot of work in Europe in teaching this new EU data law, which is, as I've tried to show, which is not data protection at all. It's a totally new topic for everybody at the university. Next slide, last slide. So if you want to follow what we do at ITM with this new European data law, we have ebooks, we have information services, we have podcasts, so you can listen to my lectures. You can see me on YouTube in a lot of fascinating, hopefully fascinating videos. So we try to find out the borderline between all these new EU acts and secrecy law and data protection law. And we hope to find at the end a kind to have a new property right in data. So that is all I want to say. Last slide, there's one slide missing, I think. We simply said, thank you for your attention. I hope I have made myself understandable, and I hope to see you and discuss with you as this series of lectures and in the internet. Thank you very much. Obrigado.
Muito obrigada, Professor Thomas. Thank you very much. And I love to hear you because Professor Thomas always gives us some philosophical thinking also. He's very deep in his thinking, his way of understanding. You are very, very clear for us. Thank you very much. And I ask to everyone who wants to make some questions, please write in the chat, because then after we can discuss with Professor Thomas.